Okay, civil litigious matters. Before we even start, I want us to basically deal with three things, and that is the three different main cost orders that you get. Okay, we've already spoken that you can get attorney. I'm writing this down, and then I'm going to show you, and I want you to write that down on a piece of paper, and keep that. Okay, you get attorney and own client, and we've already discussed that. That is an agreement between an attorney and their client. And what's it based on? Our fee agreement. Remember that mandate that we wrote, and we said like 100 Rand a letter or 50 Rand a phone call? That was our agreement with the client. Okay. Then we get party and party costs, and I actually touched on that earlier on. What are party and party costs? Those are costs between, it's basically our general rule of costs. Party and party costs are, and you're going to hear this a lot of times from me, the costs that are reasonable and necessary to take the matter further. Okay, where do we find our party and party costs? In the tariffs. Okay, so far we have our attorney and own client costs. What are attorney and own client costs? That's between an attorney and their own client. Okay, and where do we find what those costs are? In our fee agreement. Okay. Then we get party and party costs. That's our general costs order. Okay, so when my client is successful and they get a costs order, ordinarily it's a party and party costs order, which means that I'm not going to claim those costs from the loser to reimburse my client for the costs that he had paid me in terms of our fee agreement. Do you see that? Okay, so now where do I find these party and party costs? Well, those party and party costs are going to be found in the tariff. Okay, and importantly is it's only the costs that are reasonable and necessary to take the matter forward. So for example, if my client has phoned me every single day for an update, I'm going to charge my own client for every phone call that he's made. But do you think that every single phone call was reasonable and necessary to take the matter forward? No. So you won't be able to claim reimbursement from the opposition for every single one of those calls. Okay. Perhaps one over the course of like 3 months, or until something big happens and you've got to inform the client. Okay. So party and party costs, that's our general costs order for reimbursement for our client. It's between the two parties, remember. It's only costs that are reasonable and necessary to take the matter forward. And it's where do we get those numbers from? How much? It's from the tariff. Okay. Then we get a third costs order, and that is attorney and client costs. Okay. Now, that differs in that an attorney and client costs order is something a little worse. Okay. So again, if a court finds in my client's favor and I have a costs order and I want to get the reimbursement of those costs, so I want to claim the costs from the loser, then, and I got an attorney and client costs order, what that means is I can claim everything that my own client paid me for. So remember those every single day asking for an update? I'm allowed to now claim every single one of those. So it's all the costs that my client has paid me, but still only based on tariff. Okay. So do you see party and party costs is like the least amount. It's only those costs that are reasonable and necessary. It's based on tariff. Little bit worse is our attorney and client costs, which is everything that I have charged my client or that my client has paid me, but it's based on tariff. And if, for example, the court awards an attorney and own client costs order, that means that the other party, the loser, now has to pay everything that I paid my own attorney. Okay. So I'm going to show you this little diagram, and you're going to write this down on a paper. Okay. Can you see that? Okay. Maybe oh, this is very difficult. There. Okay. So jot that down. Okay. Right. Why is this important? We're going to talk about that now. Okay. We're on page 13 of your notes, and it starts off by basically talking about the concept of civil litigious matters, and we've spoken about that already. Those are matters that are in court. They have a case number. A client is always liable to his attorney for costs incurred for work done on his behalf by the attorney, and those costs are attorney and own client, remember? And they're based on a fee agreement. Now, to indemnify the party for expenses having been incurred by having to go to court or defend, then, okay, I want you to think about this. I had a car accident with you. My car was damaged. I now need to claim for my damages to my car, but you don't want to pay. So your not paying has forced me to have to go to court and has forced me to have to get an attorney. And because I have an attorney, I've had to pay my attorney. So now when I win, the court says, right, you get your money from the loser, the person who was liable to pay for the damages, but also you need to be indemnified or reimbursed for what you paid for your attorney. Okay. And that's why we spoke about those distinctions, because there are times when the court will give us a general cost order, which will be party and party. So I can get reimbursed for a little bit, effectively, based on tariff versus what I paid my attorney. Or the court can say, for other reasons, which we'll discuss, why you should be liable for a higher amount, like an attorney and client costs order, or if the court is really angry, then really wants to reimburse the plaintiff, for example, or the defendant, if they were defending a very silly matter, then the court will say, you know what, loser, you must now pay attorney and own client costs, which is everything that the winner paid their lawyer. Okay. Rules relating to cost orders in civil litigious matters. Basically, the basic rule which overrides all other relevant rules is that the court has a discretion in awarding costs. It must be exercised judicially and not arbitrarily, and after they consider the facts of each case. Okay. The general rule is that the winner gets costs. That's the general rule. But sometimes you may win, but have you really won? Okay. So for example, if I bring a rescission application, what is a rescission application? You're asking for an indulgence from the court, are you not? You're saying, sorry, man, I'm sorry that judgment was granted against me because of XYZ. Please rescind it. If you win the application, have you actually won? You won, but you were asking for an indulgence. And so the court will ordinarily not give you costs. The same is if you're asking for a postponement and the opposition says no to the postponement and you've got to bring a formal application for a postponement and the postponement is granted, the court ordinarily will not give you costs because they're saying, well, you asked again for an indulgence from the court. Okay. Sometimes also what happens is if I sue for 100,000, for example, in a car accident, and the defendant raises a counterclaim for the damage to their vehicle, and the court finds that both parties were equally as negligent as the other, yes, as the plaintiff, I've won because I got 50% of my damages, but I also have to pay 50% of the damages of the defendant. And so did I really win? Not really. Okay. So in those cases, the court will ordinarily not give a costs order. Okay. So, the court must attempt to establish which of the parties has been substantially successful. And this is in cases of like inflated claims. Let's say, for example, my pinky is broken in a car accident and I claim for damages. Okay, but let's not say that. Let's say I trip over a manhole and all I do is I break my baby toe. And I'm now claiming for negligence for the break of my baby toe. And I claim R1,000,000. And I win at the end of the day, but I get 10,000 Rand. Did I win? Yeah. But did I go there asking for R1,000,000? And if I'd maybe asked for the 10,000 Rand at the beginning, I would have got it without having to go to court? Possibly. And so the court will then say, well, you were successful, but it was an inflated claim. And then they will make a decision as to whether you should get costs at all because of your inflated claim. Another thing to look at is partial success. Let's say you've got 10 claims for different things, and you are successful in 2, but you lose 8 of those alternative claims. Are you really successful? Not really. And so the court's going to look at things like that. Okay. The court can also say, hey, no costs to be awarded to you. And they do that when they look at things like when you've made excessive demands or taking unnecessary steps, misconduct by a party or a legal practitioner, vexatious proceedings. And that basically means like just being mean. Do you know what I mean? Doing it for ulterior motives that you're taking somebody to court. Moral considerations, technical success only, and specific types of proceedings, like those when I spoke to you about like asking for condonation and things like that. Then a court will actually say, hey, you know what? No, I'm not giving costs. But the underlying golden rule is that it's always in the discretion of the presiding officer to make a decision as to whether to give you costs or not. Okay. Sometimes, even though you win, the court can make you, as the winner, pay the loser's costs. And that sounds ridiculous, doesn't it? But the court will look at things like if there was misleading conduct or statements caused the costs of the proceedings, or if the court disapproves of a conduct of one of the parties, even though you won. You won because of the law, but what you did wasn't awesome. And so the court will then say, you now need to pay the costs of the loser. Okay. And these circumstances include dishonesty or fraud, reckless, malicious, vexatious motives, or really just grave misconduct on the part in the case. Okay. Then possibly the worst thing that can happen to an attorney, and I'll give you an example before I even talk about it. Years ago, I had to oppose a very strange eviction application which was brought against my client. And when the eviction application was brought, PI, which is the Prevention of Institution of Illegal Eviction Act, wasn't complied with. And we got the entire eviction set aside, well, the application was dismissed on the basis that PI hadn't been followed. Now, we asked for costs, and the court granted an order of costs de bonis proprius. Now, what that means is, yes, the loser, which in this case was the applicant, should have to pay for the respondent's costs in having to come to court to answer this ridiculous application, but really was it the applicant's fault? Because the applicant had gone to see an attorney, and an attorney should know better than not to apply or follow the rules of PI. So the court then makes a cost de bonis proprius order. And what that means is that somebody in a representative capacity is then liable for the costs out of their own pocket. So when we tax those costs, the person who had to pay those costs to us was not the applicant, but the applicant's attorney, because the applicant's attorney should have known better. But it doesn't just happen in attorneys. For attorneys, it's anybody that acts in a representative capacity. So if somebody's acting as a trustee of a trust, or if somebody is acting as it's happened before, a claims handler in the RAF matters, if they've purposefully done something wrong or the court doesn't like what they've done and they say, you know what, the RAF, for example, shouldn't have to pay the costs. The claims handler was at fault and the claims handler should pay. Then it's called cost de bonus proprius. Now, that's not something you want, is it? Now, remember we spoke about the three tiers, if you want to call it, of a costs order, being attorney and own client, or attorney and client, or the nice one, the nicest of the three being party and party costs. A cost de bonus proprius order can be cost de bonus proprius on an attorney and own client scale, or cost de bonus proprius on an attorney and client scale, or cost de bonus proprius on a party and party scale. So cost de bonus proprius only tells us who has to pay the costs, but they may have to pay party, which would be based on tariff and only those things that are reasonable and necessary to take the matter forward, or they may be liable for attorney and own client costs, which would be everything in terms of the fee agreement. Okay. Sometimes a court can also say, you know what, you've done nothing wrong, defendant. Let's say, for example, the plaintiff sues the defendant and the plaintiff wins, okay? And it was a normal matter, and there was nothing dodgy on the side of the defendant, but the court can say, defendant, we want you to pay attorney and client costs. The court can do that if it finds that there were some seriously difficult questions of law, or there were alternative claims which maybe took it out of the jurisdiction of the court. Let's say it was 3 alternative claims for arrest, prosecution, and detention, and everyone was for like 200,000. You can still bring it out of the magistrate's court. The rules tell us that. But if you added them all up together, it would have been brought out of the High Court. Then the court can say, because of the complex nature of the matter, or the fact that all these alternative claims added up to a large amount, we believe that the plaintiff should be better reimbursed. Okay, so the court can also do that. Okay. Now, what are the different costs orders you can get? The general costs order, we've said it 100 times. Party and party costs. What are they? They are costs that are reasonable and necessary to take the matter forward based on tariff. Now, what are attorney and client costs? Those are everything that the client has paid the attorney, but based on tariff. For example, client phones every single day. We can't claim for every single phone call in a party and party costs order, but we can in an attorney and client costs order. But both of them will be based on tariff. What's attorney and own client costs? That's everything based on a fee agreement. Okay. Cost de bonus proprius, we've spoken about that already. That is when somebody in a representative capacity is ordered to pay the costs out of their own pocket. That's telling us who needs to pay the costs, but then the question is what scale. And that is either attorney and own client, attorney and client, or party and party. Then we have a costs order called wasted costs. Okay, now I want to give you an example. You're in the midst of a trial and the matter is set down for hearing on the 6th of July. Okay. Prior to the 6th of July, the plaintiff realizes, oops, some of my witnesses aren't available. Actually, no, the defendant decides, some of my witnesses aren't available. I'm not ready to proceed. And so says to the plaintiff, please, can I have a postponement? And I will tender your wasted costs. Okay. So I'm asking for an indulgence, and I'm going to pay you for any prejudice that you've suffered. Okay. What are wasted costs? Those are costs that have to now, those are costs for things that now have to be redone as a result of that postponement. So, for example, if the plaintiff had done a notice of set down, he's going to have to do a new notice of set down. So that's a wasted cost. If subpoenas were issued, okay, we need to redo those subpoenas because we have now a new date. Those are wasted costs. Being in court when the matter was postponed, It's wasted, that time. And then you've got to ask yourself something like, maybe you did your discovery affidavit. Do you think doing the discovery affidavit was a wasted cost? Obviously not, because you needed to do it anyway. It's not like you're going to redo it. So wasted costs are those costs that now, because of that postponement, for example, have to be redone. So they've been wasted. Okay? The next cost order we need to look at is what we call reserved costs, or costs to stand over. Now, this is very important that you understand what this means. This means that at the time when a decision needed to be made as to who should pay the costs of that specific appearance, for example, a postponement application, at that stage, the court could not make a decision as to who should pay the costs, but they would be in a better position to make a decision when the matter was finalized. Then we reserve those costs to be argued at the end of the matter. And I'll give you an example of one. Years ago, I did a trial matter, where first of all, we did a discovery affidavit. The opposition came back and said that we had not properly discovered, and they requested bank statements from my client over a period of like 3 or 4 years. I really didn't believe it was necessary for them to have our bank statements, but not only that, if you've ever tried to reprint very old bank statements, you realize how expensive it is to do so. Okay, so I resisted that and I said, no, it's not necessary. They brought an application to compel discovery. Okay, and we lost that application to compel. So the court said, Mandy, you need to give over the bank statements. But at that stage, the court said, we are going to reserve the aspect of costs because we will be in a better position to determine those costs at the end of the matter. Why? Because let's say, for example, I've been saying the whole time that I don't believe you need those bank statements. And at the end of the matter, even though they got the bank statements from me, they don't even use them, and it's quite clear that they were not necessary, then surely they should pay the costs of that application to compel, even though they were successful. And let me give you a little sneaky, that in that matter, they didn't even use the bank statements. The matter went to trial, and we argued that reserved costs order at the end of the matter, and the court said that the applicant at that stage, the person who brought the application to compel, had to pay our costs as well as the costs of the bank statements. So do you understand that when there's a reserve cost order, it's because we kind of don't know at that stage who should pay the costs, but we'll be in a better position to make a decision at the end of the matter. But what happens if a reserve cost order is made today and the matter only gets finalized in like 3 years' time, and you forget about the reserve costs order? What happens to the costs that were reserved? Well, the two courts deal differently with it. In the magistrate's court, the court says, if you forget to argue reserve costs at the end of the matter, then the costs will follow who won the costs in any event. So let's say at the end of the matter, the plaintiff is successful and the plaintiff gets costs. So the defendant needs to pay the plaintiff's costs. Then those reserve costs will follow that. So they'll just be part of that costs order. Okay. Unfortunately, though, in the High Court, if you forget to argue reserve costs, then each party pays their own costs for that matter. Now, that sounds not so bad, but let's say, for example, that application I told you about now, which with the bank statements, was argued in the High Court, and I had to instruct an advocate who charged me 20,000 Rand for the day. And we were in court for 2 days arguing that, and we forget to argue those costs. If we did, I would have been able to get those costs from the opposition. But because we forgot, now I can't get it from anybody. And my client basically has to just accept that he had to pay me for that. So in the High Court, if you forget to argue reserve costs, then each party pays their own costs. Effectively, there's no cost order for that section. Okay. Costs in the cause, I remember as an article clerk being sent down to postpone a matter with costs in the cause, and I didn't even know what that meant. But what it means is, let's say, for example, in a trial matter, it starts with the summons and it ends with a trial and a judgment. But during the course of the matter, there's a number of interlocutory applications, like an application to compel discovery, further particulars for trial. Perhaps there's a rescission involved, or a trial date where it's postponed. If there's a costs order in one of those interlocutories that says costs in the cause, what that means is that at the end of the day, whoever gets those costs, that costs order will apply to those interlocutories as well. Okay, so it's a cost in the cause. The next one we look at is costs of the day. Now, I want you to distinguish between costs of the day and wasted costs, because sometimes people can trick you into agreeing to one of these costs orders. Costs of the day literally mean that. Costs of that day. So let's say there's a trial and the trial is postponed, and an order is that the defendant must pay costs of the day. Then all the defendant has to pay is costs of that date. So remember when we dealt with wasted costs, the subpoenas and stuff that we had done and the notices of set down, those were done on other days. Okay? But this deals only with costs of that day. So it would be your appearance in court and anything you did for that day. So be aware that there's a difference between costs of the day and wasted costs. The next one is all costs or tax costs. Anytime you see the word costs, just being costs, then you need to know that that means party and party. And if it means party and party, then we know that it's those costs that are reasonable and necessary to take the matter forward based on tariff. Okay. No order made to costs. That basically means that each party pays their own costs. Okay. So at the end of the matter, let's say I was successful and so was the defendant. The court may say, we make no order as to costs. And that means plaintiff will not be able to recover any costs from the defendant, and the defendant will not be able to recover costs from the plaintiff. So each person will just be responsible for paying their own attorneys, which by that stage they more than likely would have. Okay. Now, there are some times in the two different courts that you will need specific costs orders. Okay. Now that means that we have this tariff that tells us what we're allowed to charge. But if something is not in the tariff, we need a specific order from court to be able to charge that or to get reimbursed from the opposition for that. Okay. In the High Court, often let's use the example of an RAF matter or a medical negligence matter. We're going to use doctors or experts. And for us to be able to claim the qualifying or the expert fees or the preparation of expert witnesses, we need a specific costs order from the court that we can claim that. Now, if you don't know that, you can get yourself into trouble. Let's say you're the plaintiff's attorney in a medical negligence matter and you've used 6 doctors. Okay? When you win, if you do not ask the court to list every single one of those doctors in the court order and to state specifically that you're entitled to the costs for those doctors, then guess what? You do not get reimbursed from the opposition for those doctors' fees. Now, any client is going to be a little bit annoyed that they've had to pay for a doctor and they're not getting reimbursed even though they won. So if you don't understand costs, you can get into some serious trouble here. If you have one advocate and that advocate is the senior counsel and they choose to take another counsel, a junior, you need a specific costs order for more than one counsel. And then magistrates court, this is an important one, and I was really made a fool of in one of these, and I want you to remember this and you'll never forget it. My very first rescission application, which I had done myself. I did it in the Mtunzani Magistrates Court, and I was so excited because I won. And not only did I win, but I got myself a costs order as well. So I was really excited about it. So what did I do? I got back to the office and I quickly drafted my bill of costs and I set it down for taxation to reimburse my client, to get money from the loser, because I'd got a costs order. And I was made a fool of, because guess what? In the magistrate's court, you are not allowed to tax interlocutory costs orders until the end of the matter, unless you get a specific order from court that cost order can be taxed immediately. In the High Court, it's different. In the High Court, if you have a cost order in an interlocutory matter, you can tax it immediately. You don't have to wait for the end of the matter. So a specific order that you will need in the magistrate's court is if you want to tax your cost order immediately and not wait for the end of the matter. If, for example, you want a slightly higher cost order, you would need a specific order because the general order is party and party. Traveling time and expenses or subsistence expenses of an attorney, you need a specific order for that. If your claim is less than 7,000 Rand and you've used an advocate, you're not going to be able to be allowed to recoup the money for the advocates unless you have a specific cost order. And then you can read through the rest of them as being specific cost orders. I have seen in papers before where they've given one of these and have said, do you need a specific order for one of them? Okay. Very important is we get settlement agreements, payments into courts and tenders. So in the middle of a matter, the defendant realizes, actually, I don't need this matter to go to trial. I'm going to make a settlement offer. If that settlement offer is accepted by the plaintiff, then that settlement offer, even though there isn't a court order, is sufficient for liability for costs. Okay, so you don't need a court order telling you that you have to pay costs. That settlement offer and your acceptance is sufficient. Okay. Now, what happens if, this is quite interesting, it's a divorce matter that you're doing and the matter is just, you can see it's going to go on forever. So you as the defendant make a settlement offer with prejudice. Okay. What does that mean? That means that I want everyone to be aware that I'm making this settlement offer. And in that settlement offer, in the High Court, it's a Rule 34 offer. You say, I'm offering XYZ. Okay. And the plaintiff decides to reject your offer. But at the end of the matter, the court orders exactly what you offered, or even slightly less. Guess what? Even though the plaintiff won, they're only going to be able to get costs reimbursed from the loser up to the date of that offer. Because it makes sense. They should have accepted that offer, but because they didn't, they made us carry on litigating and incurring more legal expenses when they shouldn't have. Okay. And if it was a vexatious reasoning behind why they rejected that offer, the court can even say they need to pay your costs. So be very aware as an attorney that when you get a settlement offer, that risk is explained to your client as well. Okay. Right. The prescribed tariffs, remember we've spoken that you can get a party and party cost order or an attorney and client cost order, and that those are based on the tariffs. Each court has its own tariff. Okay, Constitutional Court has its tariff, the High Court has its tariff, and on page 20, it talks more about the sort of distinction between party and party, an attorney-client and attorney-and-owned client cost orders. Yeah. Do you know that if you have an attorney and own client costs order, but you don't have a signed fee agreement with your client, and the matter needs to be taxed by the taxing master. Now, why does the taxing master do that? Remember, we're trying to recoup our costs or reimburse our client. And when we're doing that, the taxing master is going to decide whether what we've charged is reasonable or not. If we don't have a fee agreement to base what we're charging on, then the taxing mistress is going to say, well, based on tariff. So you're actually then doing your client a disservice because you got a really nice cost order, but now you're only allowed to get back what was party and party. Okay. In the magistrates court, on their tariff, they've split it into 4 scales. Scale A, B, C, and D. And they're in 4 different columns. Each item, for each item, it's slightly less for scale A, and it gets more expensive as we get to scale D. And how they've worked it out is they've said, listen, if something is between 0 and 12,000 Rand, your claim, then it's scale A. If it's between 12 and 20, well, it's 12 and 50, it's scale B. 50 up to magistrates court jurisdiction of 200, it's scale C. And then above that, which is regional court, up to high court jurisdiction, we look at scale D. Okay. Now, back to attorney and own clients, just a quick one that I've thought of now and I've seen in your notes. If your client is not paying you and it's a litigious matter, you can sue them without taxing the bill, okay? But they can then ask for stay of your action against them for the bill to be taxed. So sometimes what we do is we just tax the bill so that we just get it done before they even ask for it, okay? Collections, we've touched on that as well, to say that in collection matters, there are prescribed tariffs for undefended matters. And undefended matters are collection matters, where you issue a summons, there's no appearance to defend, you take default judgment, and you follow Section 65 or a writ procedure. There's specific tariffs for undefended matters, okay? Remember what we said about collection commission, that collection commission is actually for your client unless the other party has agreed to pay collection commission. Now, often when you enter into a lease agreement or you take a bond out or you enter into any agreement of loan, in the small writing it will say, I have agreed and consent to pay collection commission in the event that I don't pay. And that's enough for the debtor to have to pay collection commission. Okay. The other thing is that if you've ever signed any agreement and you look at the small print, sometimes what you can agree on in that small print as the defendant or the debtor is that you will pay attorney and own client costs or attorney and client costs. So there the court's hands are tied. The court will say, you know what, I find in the plaintiff's favor, and there was nothing dodgy, but the defendant agreed to an increased tariff. And because of that, they will now have to pay attorney and client costs. Okay. The whole attorney and own client costs issue is quite a difficult one and something that the court don't really like to award, because if you think about it, as the plaintiff, I may go and see an attorney that has 40 years experience in something and will be charging me at really quite an expensive rate, okay? The defendant might have gone to a younger attorney who's charging them less. When the court makes the defendant pay attorney and own client costs in terms of an order, effectively they're making them pay for a more expensive attorney that they wouldn't have ordinarily gone to. Okay, so just be aware of that as well. Okay.